Go ahead.
Yeah, I have one comment. It's not a big one. There is I just noticed this proposed fence. I'm not sure if it's how close it is to a water line, but I did dig and dig and dig and find an old map of all these water lines that were put in. Most PVC, and I believe there's a 4-inch PVC running parallel to that proposed fence. I don't know how close it is to the fence, but I will make sure obviously gets those plans rock. And then also it's an extra copy. We found two, so one of them's a kind of a faded copy, but you can see it. And it does have that one water line where that property is. So we'll get it rock, and then you can keep it for the LMA for future reference.
Okay.
Okay. That's all. Thank you.
Thank you. One comment, we should call before we dig, it's free service, they come down and they actually mark water lines to find them and tell you where they are. It's free service. We just did it, we clear a lot, the rotary in Walnut Grove. We called before we dig and they went through and they showed us where the lines are. He did the whole thing in an hour and a half. Took out 20 trees, it was amazing, chopped them up.
So, yeah, I think that's a good recommendation. You're liable, well, I guess whatever it is he's digging would be liable if you hit something.
We'll be the water company.
But if you call, from what I understand, if you call the dig company first, then
They are
you're kind of, yeah. Okay, any other comments on that item before we go?
Well, since the public has mentioned the access and those issues on the boundary of between lot 20 and lot 159, I wanted to point out on Mr. Waffle's map that he shows the encroachments of decking. The decking has been built onto the lot, and I guess at this time, still waiting for that encroachment issue to be resolved. And in the meantime, I'm presuming ground cover will be put down for the event and until that's resolved. So that, that access issue maybe is, must involve this deck that has been put on the lot, which is exclusive use of the lot.
Excuse me, since you're talking about my deck,
Please don't interrupt at all, thank you.
I would like to address that issue, since you're talking about my
You
deck.
don't get a chance, but you're interrupting at this moment.
Okay.
So I forgot the rest of my thought. But yeah, before we call the question, I just wanted to mention that. I don't know what else I was going to say.
Call for the question. Public comments over.
Yeah, I agree.
So if the motion was to approve
The building of the fence, the ground cover, and the other necessary things to be done in time for the May 9th event.
Okay, we have a motion and a second. I'm ready to call.
This is my encroachment.
All those in favor? Aye. Opposed? Abstained. The motion carries unanimously.
That's Leo.
That's Leo. Got it. Okay. Good. Sounds like a great project for the benefit of the town. Item 6B. Collection, lien enforcement, and foreclosure regarding delinquent assessments, accounts of estate of Robert Adams, Anthony Lee, Ronnie Lee, Dawn Olson, and Martha Esch Olson. Okay. Can you have some background on this?
Yeah, the background on this is that the process was started with a letter that I sent that gave everybody a month, a little over a month, the acknowledgement that this new process was going to be into effect, even though all the lien process has historically not been acted upon. And we've had delinquent assessments, and the assessments have gone up and up and up in these delinquent ones. They're now thousands of dollars. So when I became treasurer, I wanted to start the process to be able to notify every person who is delinquent that a letter delinquency was going to be sent out. On March the 17th, we sent out 10 of these letters of delinquency. Except for 4 of them, either the assessments, the delinquent assessment has been paid, or that there is communication with the person who hasn't paid. The only response to the letter that we actually got was from Martha S. Olshan. And her reply was in your packet here, as well as what she stated. You see the letter that the process, which was first of all the letter of delinquency that was on 3/17, addressed the property, addressed the amount that was unpaid. She then took the option of sending that back. There is some confusion about it because
May I interrupt?
Yes.
Only because you do have that also on new business.
Oh, okay.
So I didn't know, did you need to address it that
Well,
way
this
twice, or? I don't know.
I might as well do it right now.
Okay, fine.
So that, and then under new business, well, we'll
I just want to make sure you didn't forget that we also had it on new business.
right. Well, but under new business will be actually Ms. S. Olshan's
Oh,
reply and her time
okay,
to present
sorry.
her thoughts on this. She did say that she, as you can see, she wishes to inspect the LMA's financial records. Of course, these records are only on how we calculate that amount. And then she wished to submit a written statement, even though it's not signed anywhere, it's simply typed. There's no letterhead on this. I am assuming that this was from her because it was in her packet. Then she says that she wishes to meet with the LMA, which is her right to bring this before us, and so we can hear her side and understand what her logic, and maybe she has paid it that we just don't know about, and in that case she can prove that she's paid it, and it'll be a moot point. But then she also says that I wish to not dispute the entire amount owed and pay the amount owed. So I was confused about that, but I think I just gave her the benefit of the doubt, saying that must be an oversight on her part. If she wishes to address this in her presentation, that would be great.
So your letter is in this packet?
Then my response to that, which I had to do, is in the packet, and that was, of course, dated April the 8th, 2015, and it says essentially everything that I've already laid out. I've included in that her invoices from our accountant, as well as what she's paid and what she hasn't paid, and why now she owes $840. We tried to electronically email this letter and this packet, but the email that she gave us appears to be wrong for Mr. Cash as well.
It's Cass,
Cass, thank you.
no H.
Cass.
As well as Mr. Watson.
As well as Mr. Washington. So, but we did send by snail mail a copy of all this to Mr. Washington. So that's where it stands at this point. For all that, that's for Martha. The other three, the Robert Adams, Anthony Lee, and Ronnie Maiden, there was no response from. And so at this point, the next step, which we will be taking, is to file a lien, since this is a new territory for me. I'm not exactly exactly sure the process, but I will become educated about that and take those necessary steps so that a lien is filed, and then next step, if necessary, will be foreclosure.
Well, good. We've really achieved the narrowing down of the assessments, and that's important because people who pay every month, and it's not fair for them to carry the burden of those who are not paying.
Doesn't Lee owns a few other buildings?
There's 5.
He owns 5. They're all listed
A
on
garage
his,
and 4 buildings.
On his letter for his delinquent
He
assessment.
pays, he does pay, but he
Yeah,
pays
that's
a
okay.
figure that is not what he's billed.
I guess that's what's confusing. I thought he always paid, but it's not the
He
correct
pays,
amount.
he pays an amount, but it is not what he's billed. So therefore, he's falling behind.
Public comment?
Yeah, public comment?
Where do I
Please talk to
serve
the-
papers to? What physical address should I serve legal papers for my response to the
I
LMA?
thought that this building was the physical location.
I guess it is.
Well, who is the representative to serve to?
I would serve them here, whoever's here.
To whoever's here?
Yeah, yeah.
Locke Management Association, is that what you're asking? Locke Management Association.
So-
How does
I'm
this
not
issue?
sure what this has to do with
Yeah, I'm not sure how this has to do with the lien,
the lien.
what this has to do with the lien enforcement, but.
Do you have a comment about that?
I sent you or actually I sent it to my attorney, my comment, and
Your attorney
you're
comment.
supposed to be, your attorney has advised you guys to speak to my attorney and communicate on legal matters that way.
Okay, thank you very much.
You're welcome.
We don't need any, there's no vote to be taken on this item.
Information only.
Information. Okay.
Well, I just wanted to add that commend James on tackling this, because for years, we've had many different groups trying to go after this, and it kind of just fell flat. So, he would.
I think that's great that you just said that, because I agree.
I would also like to say that we've, in the past, depended on our town managers to do this very thing, and none of them would do it. When requested, pushed, asked, cajoled, forced, screamed at, they never did a thing.
Yeah, I noticed that too, and especially the last one I thought was gonna do something about it. You sure did.
It was very difficult.
Yeah.
Well, I would also like to, I could not begin to do this without Debbie's help in all this.
Well, I know it's a
Her
lot
as a
of work.
secretary has just been phenomenal. You know, I have to spell check, she organizes, she does what a secretary needs to do, and it's fundamental between the two of us that I couldn't begin to tackle all this without her efforts. I deeply appreciate it. And happy birthday, Debbie.
Oh, great.
Thank you, and thank you.
Okay. Moving on to new business. Requested meeting regarding the delinquent assessment account for Donaldson and Martha Esch Olson on their property at 13959 Main Street in Locke. Did you have an additional, this kind of overlaps with the prior item that dealt with lien enforcement? Is there something specific to the folks that don't,
Did we cover
believe that we're the United States or?
So this is to cover her request that she be headed for.
Yes.
Oh, I see.
Explain.
Oh, okay. She
Why?
checked that.
So I think I've given.
So you put it on the, you put it on the.
I have to, absolutely.
Yeah,
It's
right.
part of her right, which we
Absolutely.
acknowledge, and we inform her of that right. She's acknowledged that that's what she wants to do, and this is her opportunity.
Okay, so,
I would like to meet in executive session. That's part of your CCNRs, if you would read them.
according to the CCRs that I have for this, that's not correct.
Really?
This is not an executive session.
No, I understand. I request to meet in executive session.
It's not for you to request.
It's not? It's for you to assign?
It says,
You want to cover the bylaws or just the CCR? We have it here. Take your time. We're all sitting here.
okay, what I have is that under Article 5, there is procedures to dispute the delinquency notice. The owner has submitted a written dispute to the board within 30 days. We've responded in 15 days, yes.
May I interrupt you?
Please.
I'm going to assume, although Mrs. Olson hasn't said what she means or why she feels she needs this today rather than talking to us right now, but in the CCNR's section 4, under 4.8B, the notice owner has a right to request a meeting with the board of directors to discuss the association's claims that the owner is delinquent, as long as the request for a meeting is made within 15 days of the following the postmark on the association's notice to the owner. Ms. Olson did that. The meeting must take place within 45 days unless the board has no regular scheduled meeting within that time period, in which case the board can designate a committee of one or more members to meet with the owner, and the meeting can be conducted in executive session. But we've had having a regular scheduled meeting within the 45 days, and so that's what we're doing now. So this is Ms. Esch's opportunity, as I understand it, from the CCNRs.
I think that,
Honoring her the CCNRs.
Okay.
Yes, this
Um,
is a regular meeting within 45 days, and we have put her on the agenda for this purpose.
If she chooses.
So
may I come to the podium?
Well,
Yeah, we're
asking.
Okay.
you.
this is your
Okay.
time.
You're inviting us
To give your explanation of your assessment delinquency.
I think that my husband and his lawyer, as well as my lawyer, oh, he's gonna love to see you laughing at that.
You're just moving it around. Yeah, go ahead.
I think that my husband, as well as his lawyer, and my lawyer, would like to be apprised in an executive session as to our personal business, not in a public format like this. It's my right to ask. It says right there in your CCNRs, an executive session can be held within 45 days.
If we don't have a regular scheduled meeting, you have to read the whole sentence. And if we're wrong, we're wrong, but I don't see how we're wrong. So if you're saying you would rather not discuss
Okay.
it, is that what you're saying?
I would
You'd
rather
not discuss it?
my lawyer discuss it, and
So you're not going to talk to us about
not really, no. I don't think
Okay.
that's my place. I think that's my husband's lawyer and my lawyer to speak probably with your lawyer. Unless you have a legal advisory committee still here, and I don't know who of you is the legal advisory committee at this time.
Just so we're clear, you do not wish